Please tell us your name and roll number for this exam.
Sir, my name is A. Geetanjali-Aarohan and my roll number is 300002.
Okay. Um, Now, without telling your name, please tell us, excuse me, uh, please give a brief introduction.
Sir, I come from Puri, Odisha, and I have completed my schooling from Puri itself, class 10th from Blessed Sacrament High School, Puri. And thereafter, I went to study my 11th and 12th from Delhi Public School, Damanjodi District, Koraput, Odisha. And thereafter, I completed my 5-year integrated BA LLB honors from University Law College, Vanivihar, Bhubaneswar. And thereafter, I pursued Masters in Law from BM Law College, Puri. Since then, I have been practicing for the Judicial Services examination.
Okay. So, in your CIF, what have you given your hobbies? What are the hobbies that you have given?
Sir, I haven't given any hobbies because I haven't developed any such.
Hobbies. Okay. You're working somewhere?
No, no, sir, I have not been working.
Are you employed? Huh?
No,
Sorry.
no, sir, no. No, sir, I have
No.
not been
Okay.
employed anywhere.
Okay. You're not in employment. Okay. Fine. So, despite that, you don't get time to you did not get time to cultivate a hobby.
No, sir, because after the college, I was preparing for judicial services, so I didn't get any such time.
Okay. Okay. That is fine. So, um, any achievements that you would like to mention to us?
Sir, I have been awarded the gold medal for standing first in the 5-year integrated BA LLB examination by the Utkal University in the year 2019.
2019. You passed your LLB in 2019.
Yes, sir, 5-year integrated LLB.
5 integrated, and after that you have done your masters.
Yes, sir, 2021 it was over.
Where did you do your masters?
From the GM Law College, Gangadhar Mahapatra Law College, Puri.
Okay. Can you tell me something about the person on whose name your college is named?
Sir, he was the former law minister of Odisha.
Okay. Okay. Fine. Fine. So extracurricular activities, sports,
Sir, I love to watch cricket. That's it.
cricket. Okay.
Yes.
So who is the current captain of Indian women cricket team?
No, sir, I don't watch women cricket actually. It was only men cricket
You're not
in
interested in
Hyderabad.
women cricket? Okay.
Uh,
Okay. Okay. So coming to our uh, uh, legal questions, what are your optionals that you have taken for this exam?
Sir, law of crimes, that is IPC and tort, personal law, Hindu law and Muslim law, and law of property, transfer of property, plus specific relief, plus limitation.
Okay. So I'll start with some basics of CPC. Um,
Yes.
we'll go to procedural law first, and then other laws also will go. So can you tell me what is an interlocutory order, and when the court decides to give such an order?
Sir, interlocutory orders are also called as interim orders. They are generally passed during the pendency of the suits. They may be in the form of injunctions or generally declaratory suits, etc. They are such. And they are passed during the pendency of the suit, an application made by the party. Order 39, Order 40 deals about interlocutory orders. Even Order 38 also speaks about interlocutory orders. They are generally passed during the pendency of the suits, an application made by the parties when there is some danger that the property is likely to be wasted or damaged. And there are some guidelines also given by the court in Gujarat Bottling Company Limited case versus Coca-Cola Limited, that when there is a prima facie case established or when there is a balance of convenience or irreparable loss, in that case, interlocutory orders are passed to maintain status quo till the final disposal of the matter.
Okay, that's fine. So, can you tell me something about the circumstances in which a judgment given by a foreign court cannot be executed in India?
Yes, sir. Section 13 of the Code of Civil Procedure speaks about six circumstances when foreign judgment cannot be implemented. That is when it is pronounced by a court of incompetent jurisdiction, it is not given on merit, or it is given on fraud, it is practiced on fraud, or when it does not follow the principles of natural justice, or when it disowns the international law or refuses to accept the law in force in India, or when it is founded on breach of law in force in India. In that case.
Mhm. Okay. Um, can you tell me what is the difference in the revisional powers of High Court under Section 115 of the CPC and under Article 227 of the Constitution of India?
Uh, Sir, Section 115 of the CPC applies to it is actually a writ of certiorari in nature. The revisional power is exercised in three circumstances. That is when the lower court has refused to exercise the jurisdiction, or when it has exercised the jurisdiction not validated it by law, or when it has exercised the jurisdiction erroneously without considering the evidences, etc. And Article 227 empowers the High Court to exercise revisional jurisdiction by withdrawing a case before itself and disposing of. Uh, um, it is like a writ petition.
Okay. So you mentioned writ petitions. So also you mentioned certiorari. So what is the difference between certiorari and prohibition?
So certiorari is after judgment is given, and prohibition is before judgment is given. It is like prevention, but certiorari is like correcting an order which may be wrong or which has gone wrong.
Can certiorari be preventive? Can it be used for prevention also?
Mm, I have no idea, sir. I will have to read over it.
Oh, okay, okay. Suppose a court which does not have pecuniary jurisdiction has given, okay, a judgment. So now, will that judgment be a nullity?
Sir, it will not be a nullity unless it has occasioned failure of justice. Section 18 of the Code of Civil Procedure speaks about that.
Okay. So in which case, okay, suppose um, there is, irregular. What is the concept of irregular jurisdiction and nullity?
The nullity means void ab initio. It is totally void from the inception.
Okay,
And irregular means where it has assumed a jurisdiction which may not be vested in it.
okay.
Maybe on improper grounds or proper grounds, maybe, without any deep analysis.
Now suppose there is defect in the subject matter jurisdiction. In that case, will it be a nullity?
No, sir, unless there is a. Sorry, sir, I will have to I think read over it. That
Yeah,
would be
yeah. You
cool.
can just take it down. Okay. In which defect in jurisdiction, your judgment will be a nullity. Okay, that is just go through. Okay. Uh, can you tell me who was the first uh, Chief Justice of India, woman Chief Justice of India?
Fatima Bibi, Srimati Fatima Bibi.
First Chief Justice of India, woman Chief Justice
Oh,
of
sorry,
India.
sorry, sir, sorry, the first justice. No, sir, there is no Chief Justice of India yet now.
In the current seniority list, do you have any idea that someone has a chance of becoming that?
Yes, sir, Justice Nagaratnam, she has a chance to become by 2027.
Okay, good. What about Odisha High Court? First judge, woman judge of Odisha High Court?
No, sir, I have no idea.
Okay, so that also legal GK also we can
Yes,
ask. Okay, so just go through that
yes,
part.
I'll go through.
Currently, how many
Please.
uh, women judges are there in the Supreme Court and in Odisha High Court? If we can name them.
Sir, in Supreme Court, I can name Justice Nagaratnam, Justice
Hmm.
Hima Kohli, and Indira Banerjee, ma'am, just retired now. Uh, and
So
well,
two.
I don't have any idea. Maybe so many, but I have no idea.
Okay, okay, just go through this part. Okay, fine. So
Yes, yes, I'll go.
um, coming to fundamental rights, is there any restriction imposed on the fundamental rights of defense personnel by the Constitution, or they enjoy the same fundamental rights as a common citizen of India?
Yes, sir, there are restrictions on the defense personnel. I guess Article 31C deals with it. Article
Sorry,
31C. Article
Thir-
31C, I guess.
31C.
Sir, maybe I am
That
wrong,
is
but I
basically,
think
yeah, a 31C is for a different purpose. The exceptions that is given there. Okay.
sir, I believe.
Um, what is Article 370 and what is your opinion? What is the legal status of Article 370 now?
Sir, Article 370 provides for temporary status for a limited period, a special status to the people residing in the state of Jammu and Kashmir, and now it is abrogated as on 5th August 2019. Um, Sir, actually,
So
it was a temporary.
Article 370 has been struck off, abrogated as you have said, that is not there in the constitution now, or they have amended or changed or toned it down, but it still exists. What is the case?
Sir, actually, it is struck off. It is abrogated now as on the Jammu Kashmir Reorganization Bill, which is now an act of 2019, and which
Hmm.
provided for some special status to the people, and it now doesn't exist. As for now, people and 35A is also not existing currently. It provided for a special status, but now it is not applicable. The common laws across India applies to the state of Jammu and Kashmir.
Okay. This part that it has been struck off from the constitution, check that again whether Article 370 is still there in the constitution or it has been completely struck off. Okay, or it has been toned down. Right.
Yes,
And as
yes.
you said, that Article 35A, okay, so related to that, they have changed it. So you can just go through the details of it. Okay. So in Muslim law, have you heard of the term hiba? HIBA,
Yes,
hiba.
sir.
What is that?
Yes, sir. The hiba means gift in Muslim law.
Okay, and what are the types?
So there are hiba bil iwaj, that is gift for consideration. Hiba bil sato liwaj, that is gift for stipulation. Sadak, which is a gift made for religious purposes. And Aryat, that is a grant of license which is granted at the grantor's option to enjoy the property for certain period of time without transferring the ownership.
Okay. So this right of issuing writs or the power to issue writs has been given to Supreme Court and High Court. Can you tell me the difference in the writ issuing powers of Supreme Court and High Court?
So the powers of the writ issue by High Court is much wider than Supreme Court. In Supreme Court, the writ can be issued for enforcement of fundamental rights, but in High Court, that can be for other legal matters also.
Okay, that is one. Any other difference that you know?
Sorry for not being able to recollect.
Okay. Um, Have you heard of the case in Evidence Act related to evidence law related to R versus Bedingfield?
Yes, sir.
So it is related with which concept? Can you tell me?
Yes, sir. It is related with Section 6, that is res gesta, the importance of time. That is,
Hmm.
once time, that interval of time has lost, then the evidence stands of no value. The statement must be made immediately and not after a lapse of time when there are chances of tutoring and conquotation.
Okay, so can you just tell me in short what had happened in that case?
Yes, sir. A woman with a throat cut comes out of a room and says that someone had did it to her, and that statement lapse was discussed there. The time lapse was discussed there. That the statement must be made recently and not after a sufficient time has passed, and it must be an expression of emotions generated by the event and not a subsequent narration of the incident.
Okay, so this in this R versus Bedingfield, what is this R,
R means regime.
which means
So I think Queen or those type of people who existed at that time.
like we are using Union of India?
So, yes, yes. At that time, who was the head? I guess on their name maybe.
Okay, you can just go through that. Okay. Can you tell me what is
Yes.
the difference between a solicitor and advocate in India, for example?
The solicitor, I guess, represents the government, and advocate can represent a private person also.
Do we have solicitors in Odisha?
The advocate general is there, or solicitor general is just representing the central government law officer.
Okay, so
But I
just go
think I
through
have to
that.
go
Okay,
through that.
solicitor.
Mhm.
Basically, that
Yes,
concept is prevalent only in Bombay or Mumbai. Okay, and
okay.
so
Yes,
it
sir.
has a lot of technical points in that to be a solicitor, because for the according to the Advocates Act in India, the advocates they
Mm,
cannot solicit. Okay, solicit work or advertise their work, etc. Okay, so it is only there is a separate provision for that, and it is only there in Bombay or Mumbai. Okay, this point you can just go through. Okay.
mm,
Um, in Contract Act, can you tell me what are the ingredients of free consent?
Sir, contract, I haven't gone through that subject actually.
Okay, okay, we can skip that. Okay. Uh, can you tell me what is the meaning of affray?
Yes, sir. It is fight between two or more persons in the public place causing disturbance or annoyance among the people. It is provided in Section 159 of the Indian Penal Code, and punishment is given in 160.
Mhm. Okay. What is this concept of lis pendens?
So, lease pendants means pendency of litigation. It is founded on the maxim of interest republican ut sed finis litium, that is, it is in the interest of the state that there should be an end to the litigation, and pendente line nihit innovation, that is, during pendency of the suit, nothing new can be introduced. The concept is founded in Section 52 of the Transfer of Property Act 1882, that during the pendency of the suit, it is advisable for the parties not to transfer or alienate their immovable property, for which there will be litigations, and there would be no finality to any matter. However, any such alienations would not render it null and void or invalidate it, but render it subservient to the result of the suit.
Mhm. Okay. Can you tell me what is unlawful assembly?
Yes, sir. Section 141 of the Indian Penal Code 1860 defines unlawful assembly. It is an assembly of five or more than five persons who gather with a common object of overthrowing or overawing the government established by law, or to resist any law or legal order, or to commit mischief or trespass, or to dispossess a person from the property or obstruct any way or water course or any enjoyment of right or supposed right, or to compel a person to do any act which he would not do or omit to do something which he is bound to do. These common objects make them a part of unlawful assembly.
Okay. Suppose a person is of unsound mind and he commits a crime. Okay. What is the criminal liability according to Indian laws that can be attributed to him?
Um, mhm. So Section 84, that is General Exceptions chapter of Indian Penal Code, says that where an offence is committed by an person of unsound mind or an insane person is no offence, because a mad man is himself punished by his own madness. So no law can punish him at that end. But however, there is no such presumption. Law raises presumption of sanity as per Section 105 of the Indian Evidence Act, that there is no presumption of insanity. But yes, he can burden of proof lies on him to show that at the time of committing offence he was insane. But otherwise, juratio furi sui punior, that is a mad man punished by his own madness. So law does not take into account his culpability.
Okay. So section 300 of IPC deals with what?
Sir, it defines murder.
Okay. And what are the exceptions under it, under section 300?
So there are five exceptions to Section 300, which is grave and sudden provocation and acts done by the public servant may be exceeding their powers or exceeding the right of private defense or a sudden fright or consent of the victim when death is caused with the consent of the victim is above 18.
Mhm. Okay. So, what is your view on this recent controversy that is going on related to the hijab, allowing of hijab in classrooms in Karnataka?
So the Karnataka High Court dismissed a petition allowing hijab, stating that they are not essential religious practice in Islam. And the purpose of that uniform dress code is to promote a sense of equality among the students. They are not banning it outside the school or outside the out in any public place, but just in the classroom. So because if they are allowed, then other communities, other religious communities may also claim the same for their religion, and that would create a sense of anarchy. Because in school is the best place for promoting equality, because so as to prevent discriminations on caste, religions, etc. The rest, it is sub judice matter before the Supreme Court, and we all are awaiting that judgment.
Okay. What are the, tell me in short, what are the rights of an arrested person?
Sir, arrested person has right to be represented by a lawyer of his own choice. He has the right to inform his friend or family and inform them about his arrest. He has the right to have the copy of medical report where he has undergone medical examination under Section 54 of the RBC. He has the right to be known about the grounds of his arrest so that he can prepare for bail or he can represent himself in the court properly, knowing about the allegations. And he has the right of medical examination also.
Mhm. Okay. And this was given in which case? Supreme Court has given this in which case, if you remember?
So, yes, sir, in DK Basu versus State of West Bengal.
Mhm. Okay. Okay. So, what is your view? That women are underrepresented in higher judiciary. So, what are the steps that can be taken to improve this situation?
Sir, that may be because that the collegium generally consists of male persons, so there may be male dominance over that collegium selection matter. That's why women representation is less. But that has been overturned by the appointment of so many women judges in recent times. And recruitment of
Mhm.
women process is been going on. Unlike in the previous times, it has been going on. Still, there is a long way to go.
Okay. you mentioned about the collegium system. So there has been a lot of criticism regarding this way of um selection of judges for High Court and Supreme Court. So can you tell me the history of this, especially with reference to the four judges case, and if you can um, provide some alternative, and has the government tried anything like the NJC or something?
Sir, in the first judge's bench, the word consultation was an issue, and it was held that the president is not bound by the advice of the collegium and with regard to selection of judges. But that was overturned in second judge's bench when surpassing three senior most judges. Justice Ray was appointed as Chief Justice of India. Thereafter, it was held that the consultation means concurrence, and the president is bound by the advice of the collegium. Finally, in the third judge's bench, it was held that collegium means the Chief Justice of India plus the four senior most judges of the Supreme Court, and even two of them do not agree to the selection process. The government is not bound by the appointment, not bound to appoint that person as Chief Justice and or judge of the Supreme Court. And in the fourth judge's bench, NJAC bill was an issue. NJAC bill sought to include the members from the government, especially the law minister, political persons, and thereafter that would be against the principle of Article 50, which provides for separation of powers. And that's why that was been struck down to maintain that independence of judiciary. And in my opinion, this collegium is, I guess, the best method. Yes, there are criticisms because they are not telling the qualifications or on what basis one judge is preferred over the other judge. There are lacunas, but still it is a good process going on.
Mhm. And okay, NJC. Do you know why, on what grounds NJC was termed as unconstitutional by the Supreme Court?
So the Supreme Court struck it down, struck down the 99th Constitutional Amendment Act because that sought to include persons from political parties, the Minister of Law, etc. They have got that principle from USA, where when Donald Trump was the president, he selected some a person who shared the same political agenda with him, and the court thought that it was an interference. The Supreme Court thought that it was an interference with its independent procedure, which it has got carried out. So it struck it, applying the principle of Article 50, because judiciary has the right to be impartial, independent. That's why they struck it.
So, can you tell me when was this High Court of Odisha established?
So sorry, sir. I will have to read again.
No. Okay. Just check it. Okay. I think it's 1 year after independence, 1948. Hmm. Earlier, uh, okay. So, what is your native district?
Sir, I'm from Puri.
You're from Puri. Okay. So there is a um, demand since many years that there should be a high court bench, okay, in the western parts of Odisha, because it's very difficult for the people to travel such long distance and come to Cuttack. Mm. Government of Odisha has also many times uh, demanded this from the center. Center is also willing, but the thing is that there are certain rules or certain guidelines given by the Supreme Court. Some points of those guidelines do not, okay, that checkbox, they are not checked. Okay, that in case of Odisha. Can you tell me exactly technically why it is taking such a long time, or in which of these conditions which were laid by the Supreme Court, uh, Odisha's case is not okay? It is basically we are lacking those points.
Sir, I don't have any idea. I have to read that.
Mhm. Okay. Okay, fine. So that will be the end of the interview. The feedback ହେଲା ଆପଣଙ୍କର content of the answer is very good. ठीक ଅଛି। and gotte khali jinsa hela maybe eta network problem pai hochi ki nahi mu jan parni but your flow of speech okay is very fast ठीक है तो केबे केबे सेटा मे बी से सामना लोगों को बुझिबारे असुविधा हे पारे सेटा एक्चुअली मे बी नेटवर्क इश्यू आल्सो मु सेटा जानि परनी तेणु once you come to this panel interview तो सेटा हमें देखि दबा but that does not mean that you should like consciously lower your pace of talking and सेथरे ले कोन ना basically अधिका time आपन को सेथरे पड़ेबो you will become conscious and also that will negatively affect your performance. Content wise your answers are quite good and those answers which you don't know you just tell them that you don't know or you are unable to recall okay at that moment. So if I have to give marks out of 100 you can get around 85 for today's interview. Okay.
सर बट मु जो कॉन्ट्रैक्ट एगुड़ा सब जानी नहीं तो एबे टाइम भी नहीं था विषय किछि पढ़िया पे आई शुड से नो सर.
Interview it really like if they ask you 15 question doesn't mean that you will answer all 15 आपण पांचटा क्वेश्चन भी बहुत भलो आंसर करले जेतिके आंसर करछन सेटा केमती आंसर करछन ओके ता ऊपर रहइबो. And of course since you have already mentioned in your achievements that you are a gold medalist तांकर टिके expectation टिके अधिक रहबो आपण गटो राइट तेनो से जिंसटा आपण टिके माइंड रे रखिबे but you will do good in interview okay तो किछि problem नहीं you will get good marks in interview right. Okay, I'll just a minute. I'll stop the recording.